Welcome everyone to the committee hearing of the House Committee on Judiciary and Hawaiian Affairs. Today is Thursday, February 22nd, 2024 at 2 p.m. here in conference room 325, and we're also running this hearing via video conference as well. We're hearing a number of measures today, and I would ask that the testifiers please limit your testimony to 2 minutes, and I'll ask you to wrap up at that point, summarize. If you're testifying via Zoom, please keep yourself muted and your video off while waiting to testify, and then after your testimony is complete, please mute yourself again and turn your video off. If you have any technical issues, please use the chat function on Zoom to chat with the staff. Don't send me any messages, though, because I won't get them. If you're disconnected, don't panic. Just come on back, and we'll try to fit you in when you return and provide your testimony. If the power goes off in the building here and we have to reschedule, I'll make sure that we post appropriate notice and let you know when the meeting and decision-making will take place. If you're testifying on Zoom, please avoid using any trademarked or copyrighted images because that kicks us off of YouTube, and that's no good. Please conduct yourself with aloha, and please do not use any profanity or uncivil behavior. It's okay to disagree, but let's not be disagreeable. Moving on, thank you to all the members for being here, and the rest of them are either watching in their office while they're doing other things or they'll be here presently. First up, we have House Bill 1601 relating to criminal justice reform. These first four bills, we worked to actually, last session we passed a bill, House Bill 1336, which was this committee's effort at omnibus bill as it related to criminal justice reform. And many thanks to Representative Ganadin, who worked hard on that. We decided this year to take the bill and split it up into multiple parts. And I realize it's a paradigm shift for people, and obviously it's still work in progress. And I appreciate everyone's opinion on these, and that's what the testimony's for. But we were trying to move forward with criminal justice reform, and these four bills are a package of bills that we're interested in your feedback, and so we'll begin our testimony first with HB 1601 relating to criminal justice reform. This requires law enforcement officers to issue citations in lieu of arrest for certain offenses. First up, we have testimony from the Attorney General, Mark Tom. Welcome. Please proceed.
Thank you, Chair. First up, okay. Good afternoon, Chair, Vice Chair, members of the committee, Deputy Attorney General Mark Tom for the department. The department opposes House Bill 1601. As you can see in this bill, there's a plethora of misdemeanors and petty misdemeanors that are very dangerous and necessitate discretion by law enforcement officers to effectuate an arrest. You can see from other testifiers, this is not, our testimony does not have a complete list. It does also not include things that are outside the penal code as well. So just putting that to the committee. Without the discretion for arrest, the unintended consequences of this bill is essentially that all these petty misdemeanors and misdemeanors could be rendered basically unenforceable. What's really concerning for the department is not in the criminal realm too much, is that it has a severe negative impact on the Hawaii Criminal Justice Data Center. That's basically the repository for arrests and convictions, criminal arrests and convictions. The reason why that's really important is because a number of agencies utilize this repository to do background checks. You have Department of Human Services. So some of these that we're talking about is foster care applications. We're talking about Department of Education when they're doing employment background checks before a hire. We're also talking about firearm permits. All of these things are all done through this repository, and if these are not, the ramifications of this bill would that the repository would not be updated and be current, which would render these background checks incomplete. And so we are in opposition of House Bill 1601, and we will be here for questions. Thank you.
Thank you very much. Next, we have testimony from the Office of the Public Defender. Welcome, Mr. Lowenthal. Please proceed.
Thank you, and good afternoon. The Office of the Public Defender supports this bill. We believe that all too often officers will make an arrest, which is frankly unnecessary and has a lasting stigma that is outlined in the written testimony. I am also available for questions. Thank you.
Thank you. Next, we have testimony with comments from the judiciary. Welcome. Good to see you in person. It's just fine to have you in person.
Sorry, I got stuck in another committee meeting, so I'm
I
here now.
appreciate you being here. Please proceed.
Good afternoon, Chair, Vice Chair, members of the committee. The judiciary, for the most part, stands on our written testimony. We are not able to support this measure currently as drafted. It does prohibit a law enforcement officer from arresting an individual under any circumstances for petty misdemeanor, and violation offenses. We've listed out some of the more concerning, it's not an exhaustive list, but more concerning offenses that would be impacted by this. And I just would like to point out, with respect to what we had addressed as what perhaps may be an unintended consequence, if an individual who is approached, the officer comes to them in the middle of an offense, or they get pulled over for a DUI, say, and that individual doesn't provide them with their identification or answer any questions about who they are, the citation will have to be addressed to a DOE defendant. We will have absolutely no way of making that person appear in court, that person will get a citation if they don't show up. We can't even prove that the person who's sitting there is the DOE defendant in question. And it won't take too long for everybody to kind of figure out that this is the way to do it and get around getting the citation altogether. I will be here to answer any questions.
Thank you very much. Next, we have testimony from the Honolulu Police Department. Welcome. Please proceed.
Good afternoon, Chair and members. I'm Major Lynch with the Honolulu Police Department, and we oppose Bill 1601 for various reasons. The previous testifiers did testify to a lot of our concerns, mainly which one of them is we have no way of proving who it is that we're citing. And so if you are good with that as fellow citizens in our community, that we're giving citations to Mickey Mouse and that Mickey Mouse isn't going to go to court, then the whole process is kind of asinine, if you ask me. There are specific situations that are a problem when it comes to, say, abuse of a household member, which is a misdemeanor. And, you know, all the work that we've done over the years for domestic violence is now out the window in the sense that if we come to a domestic violence situation and where we would normally arrest, we're going to give the offender a citation and then leave to allow this person to continue whatever violence that was going on. It just doesn't work that way. By allowing officers the discretion to decide what's best in that situation for those that are involved, which is currently in place now, would be the best way to basically leave it. To make it mandatory that we cite people for all misdemeanors and all petty misdemeanors is a bad idea. We stand on our written testimony, and I'm happy to answer any questions if you have any.
Thank you very much. Next testimony from the Honolulu Department of the Prosecuting Attorney. Welcome. Please proceed.
Thank you. Good afternoon, Chair, Vice Chair, and members of the committee. The Department of the Prosecuting Attorney for the City and County of Honolulu strongly opposes this bill for a number of reasons, some of which have already been mentioned by the other testifiers. And I just want to echo what was just said, but from our friends from the Honolulu Police Department, especially in abuse case or violations of protective order cases, it would be extremely dangerous to the victims, the women and children in particular, if police showed up to a scene of an offense, got their information, issued a citation, and then left the abuser to be free to do what they've been doing so far. It's important that those abusers be arrested immediately in order to provide immediate safety for victims of abuse. And in terms of TRO and protective order cases, those are orders that are issued by a family court because domestic abuse has already been found. It's important that those individuals who violate court orders be arrested rather than being given a citation and being told to appear in court again. The discretion that officers have is already provided by statute, so it's not that officers just decide on their own whether or not they should arrest or not. There's clear rules and guidelines to officers on when they can arrest and when they should not arrest. And I'd also like to point out, and this is also provided in our written testimony, that when somebody is arrested, bail is set, so they can either post bail, or when they appear for their arraignment, they can ask for release, either supervised release or release on their own recognizance, which is the case in many of our misdemeanor abuse cases. I'll be around to answer any questions. Thank you.
Thank you. I appreciate that. Next, the County of Hawaii Office of the Prosecuting Attorney on Zoom. Mr. Walchin, please proceed.
Aloha, Chair Tarnas, Vice Chair Takayama, and committee members, Hawaii County Prosecuting Attorney Keldon Walgen. We stand in strong opposition of this bill. Although this bill is intended to address jail overcrowding and support police efforts, the unintended consequences of the bill will directly contradict its purpose. We share in the arguments and the considerations shared by the Department of the Attorney General, Judiciary, and Honolulu Police Department. Simply put, this legislation simply is unnecessary. Section 803-6, as currently drafted, already provides police with the discretion to issue a citation in lieu of arrest. This bill takes away the discretion, as noted by the Honolulu Police Department. It results in possibly jeopardizing public safety and puts victims at risk. HB 1601 prohibits police from making arrests, as shared in a number of different long slew of criminal charges. Imagine the safety concerns if police are not able to arrest a suspect of family abuse. Think about the potential danger to the victim, the family, the keiki, and what if impaired drivers decide to drive after being cited? And I'm sure a lot of us have all seen the viral videos online related to the increase in theft at large-scale retail establishments on the continent. It's this committee's kuleana to study examples set by other states that have already implemented similar measures and consider the potential public safety concerns before enacting similar legislation here in Hawaii. I'd also like to take this opportunity to address some misconceptions regarding jail overcrowding, especially on Hawaii Island. According to available data, HB 1601 will not drastically reduce the jail population at the Hawaii Community Correctional Center, or HCCC. HCCC is Hawaii Island's main correctional facility and the focal point of a lot of discussion related to overcrowding. According to the Department of Corrections report dated February 19th, HCCC continues to be the state's highest overcapacity correctional facility at 132.3%. 299 are currently in custody at a facility with an operational bed capacity of 226. However, what's important to note is that 93% of those at HCCC are being held on felony matters. 93%. So only 7%, a total of 21 individuals out of the 299 in custody at HCCC are being held on misdemeanors. 4 of those 21 are currently serving sentences, leaving 17 in custody pending trial. Now, I wasn't able to look up all those individual cases, but I can say with a very high degree of certainty that of those 17, it is extremely unlikely that any of them are being held in custody on a single charge or a single case. It's also important to know that courts rarely maintain bail for misdemeanor or petty misdemeanor offenses. Most are granted supervised release or unsupervised release, quite often granted release after committing new offenses. I don't disagree that we need to address jail and prison overcrowding, but jeopardizing public safety concerns simply on account of overcrowding is wrong. Instead, let's focus on supporting funding, staffing, and programs for supervision and reintegration services, and incorporating alternative forms of court supervision, such as electronic monitoring. Let's prioritize facility repair, relocation, construction of new correctional facilities that have the infrastructure to both house serious offenders and accommodate rehabilitative care and treatment, substance misuse, mental health, social services, cultural education, and reintegration assistance to reduce recidivism and promote public safety. We have to restore the public's trust and confidence in our criminal justice system. HB 1601 is offender focused. Let's not forget about the victims. We need to ensure that there is accountability, equity, and justice for victims. Phrases like revolving door and slap on the wrist shouldn't be used to describe our criminal justice system. Let's work together to address that. There is staunch opposition of this bill from police prosecutors across the state, numerous community organizations who support victims, and individual community members and victims of crime. Please consider their input. The unintended consequences of legislation like HB 1601 will undoubtedly create more problems, traumatize and leave victims unprotected, jeopardize public safety, perpetuate negative sentiments and public perception of the criminal justice system, and result in increases in crime. We submitted our written input, and I'm available to answer any of your questions. Mahalo.
Thank you very much. We've received testimony also from the Office of the Prosecuting Attorney, the Maui County Department of the Prosecuting Attorney, the Hawaii County Police Department, Kauai County Police Department, ACLU of Hawaii, Community Alliance on Prisons. Welcome, Ms. Brady. Please proceed.
Good afternoon, Chair Tornes, Vice Chair Takayama, and members of the committee. Kat Brady testifying in strong support for this measure for Community Alliance on Prisons. So, you know, the National Council of State Legislatures describes citations as an order issued by law enforcement that releases a person on a promise that they will appear in court. I looked at their site, and then I also checked Hawaii data. At the October conference of the Breaking Cycles Symposium, they reported that 75% of all people in jail are actually Class C and lower. So then I was really curious, and I started looking to see what was that. And basically, 10% of the people are in for technical offenses or violations, 15% on misdemeanors, 10% on petty misdemeanors, and 40% were C felonies. And I would hazard a guess to say it's mostly drugs. And more data, 86% of the total state corrections population needs substance use treatment. 56% of the jail population and pretrial detainees who are innocent until proven guilty, but they're sitting in jail. 49% of new intakes need mental health services, and 30% of OCCC's population were actually houseless before they were admitted to jail. I also included, and I think the chair distributed from also the NCSL, a list of states and what they do on citations. So you can just get a flavor for how people are feeling. Thank you so much.
Thank you very much. Is the ACLU of Hawaii here? Oh, please. Sorry about that. No worries. Please introduce yourself and proceed.
Good afternoon, Chair Tarnas, Vice Chair Takayama, and committee members. My name is Wookie Kim. I'm the legal director at the ACLU of Hawaii, and our organization supports this measure. This bill is important because it takes a very significant step in reversing one very harmful norm in our criminal legal system. And that's the idea that everyone suspected or accused of a crime should be locked up pre-trial. And while others have testified about needing to look out for the interests of victims, of course we need to do that. At the same time, we also need to look out for the interests of people who are victims of a system that over-arrests and over-incarcerates. And specifically, our organization has seen the deep harm that can be caused by false or overly zealous arrests. We have 2 pending matters involving the handcuffing and arrest of a 10-year-old girl and a 15-year-old boy, right? And so the harm from those incidents is lasting, and as others have testified, it can lead to stigma and problems that will follow these people for the rest of their lives. So, I think that needs to be taken into consideration as this measure is being considered, and we acknowledge, of course, that there are situations where exceptions might be warranted, and but the point is that this bill is really, really important and significant because it's the overall thrust is trying to reverse this norm of, by default, arresting people simply because they were accused of a crime. And so for those reasons and for the reasons stated in our written testimony, the ACLU of Hawaii supports this bill. Thank you.
Thank you very much. Next, we have testimony from the Hawaii State Coalition Against Domestic Violence. Ms. Mercado, welcome. Please proceed.
Good afternoon, Chair, Vice Chair, committee members. I'm Angie Mercado, the Executive Director of the Hawaii State Coalition Against Domestic Violence. And we are in opposition of this bill, and we respectfully request that it be deferred. We think that it needs a lot more community conversation and what it looks like from an impact on survivors and victims of crime, specifically in that the type of offenses that would be included in this bill would be our definition of abuse of a family household member, and violations of a protection order, whether they're permanent protection orders or temporary restraining orders, and those are really serious indications for safety for not only our survivors, but also for the general public as well. And we think that it sends the wrong message to survivors. It sends the wrong message that if you're gonna actually have the courage to finally report and call the police yourself, or if your neighbors have done that, then your abusive partner is only going to get a mere ticket, asked to come to court several weeks later, And if they don't show up to court, then there will be a bench warrant for them. Meanwhile, a survivor does not have an option for safety, to be able to go seek emergency shelter, go to another family member someplace else because that abusive partner is right there looking at them. We need to take much more consideration of safety matters for our community. We appreciate the intent of this bill. We know that many survivors get caught up in this system as well, but we cannot do a blanket approach to these types of reforms without taking into consideration the impact on survivors of domestic violence, sexual assault, and stalking. I'm available for any questions you may have. Thank you.
Thank you very much. Next, we have testimony from MAD Hawaii. Welcome. Please introduce yourself and please proceed.
Good afternoon, Chair Tarnas, Vice Chair Takayama. My name is Arki Kale, Public Policy Chairman of Mothers Against Drunk Driving Hawaii. I apologize for the late testimony. Thank you for hearing me.
Sure.
I did almost everything that's been said in opposition. The nightmare of citing a domestic violence perpetrator and walking away is, to me, is identical to the outrage of a drunk driver being pulled over, failing a field sobriety test, and then being handed a citation and told to please stop changing lanes or whatever he was originally pulled over for. These are violent crimes. We've always said at MAD nationally that drunk driving is the most frequently committed violent crime in America and has been for years and years. This is not something I and I don't think the public could possibly tolerate, the idea that you would let a drunk driver go on his way with a citation with the full knowledge that when he returns for his court date, he will no longer have any blood alcohol content to measure. I mean, that person has to be taken in, if he fails the field sobriety test, taken in immediately to the nearest police station for a blood alcohol test. And that's largely what the system depends on, as you know from other bills this session. So I would just be astonished at the public reaction to a bill like this if it passes through as originally worded. Thank you for allowing me to testify.
Certainly. Thank you for testifying. Next, we have testimony from Shana Wailana Kukila. Please proceed on Zoom.
Thank you, Chair. My name is Shauna Kukila. I am in Hilo, and I oppose HB 1601 for the same reasons everyone else has. And I also wrote an extensive testimony about my experience with the reporting of an assault I incurred from a family violence incident in 2022. And, I'm discouraged because there are many gaps in the system that are currently not being addressed, such as protocols for the police to deal with domestic violence calls and protocols for victim witness and access to justice for victims. So I think that instead of helping victims of crime, this bill actually widens those gaps to the access of justice that we have. I do sympathize and empathize with those who are wrongly arrested, and I feel that shouldn't stay on your record, because I think it should be just a conviction that stays on your record and is considered a ding against your record. So I really strongly oppose HB 1601 as it is written, and I hope that you will take consideration of all the testimonies that are on behalf of victims. Thank you.
Thank you very much for your testimony. We also have Dennis Dunn. Not present. In addition, we've got written testimony from 6 people in support, 18 people opposed. Is there anyone else here or on Zoom wishing to testify in House Bill 1601? Yes, Mr. Yukutake. Please introduce yourself and proceed.
Aloha, committee. Todd Yukutake. I oppose this bill. Just submitted my written testimony. I feel this bill is too broad in what it does, and that police sometimes need the flexibility to make arrests. So I think you have to greatly narrow the scope of this bill. because I think as is may make my community less safe. And, also, if there's a problem with prison space, jail space, I'll build the jail, build it in my backyard in IAEA. I'm fine with that if it reduces crime. But thank you.
Thank you very much. Anyone else wishing to testify? If not, questions, members? Representative Ganadin, please proceed. Bring up that microphone so everyone hears you.
To the Honolulu Police Department. Afternoon, officer.
Hey.
Hey, can you tell the committee what the current process is for potentially giving an individual a citation in lieu of arrest for a petty misdemeanor, not a full misdemeanor?
So currently, those two are wrapped together, misdemeanor and petty misdemeanor. You can arrest and/or cite, currently under the way the law is written. There are criteria involved which we would use to say, as an example, let's say you've done a misdemeanor and I right now have a choice of either arresting or I have a choice of citing, okay? Before I do that, I'm gonna make sure, one, that you're not a danger to the immediate public based on what it is. Maybe we're in a park and you beat somebody up and if I were to give you a citation and leave, that wouldn't be a good idea. Maybe I look at your history and you've got 50 examples of when you didn't show up for court. Why would I expect you to show up for court for the 51st time? So that has a lot to do about how we make the decision on what we're going to do. What's also should be brought up is, I wasn't clear earlier when I used the Mickey Mouse thing, but if you don't have an identification, I got to go based on what you're telling me. You could use your brother's name. You could use your neighbor that you don't like's name. I mean, it can go on and on and on. If you get arrested, you go to the station and we take your fingerprints. It gets inputted into the AFIS system, which now, no matter what you say you are, we now know that you are this person and not somebody else. There's been homicidal maniacs caught because they were lying to police, and yet when we arrested them, brought them to the station, and we ran their prints, it wasn't Mickey Mouse, it was the homicidal guy. And so if we don't have that process in place, then there's no way of tracking anything, really. The only people that are gonna honor this system are the people that respect the law.
So most traffic infractions are considered things that you would cite for instead
Correct.
of arrest for.
Correct.
So what happens in that instance when somebody doesn't have a form of identification?
Well, in the instance of the scenario you're bringing up, they're in a car, they're required to have a license by law to drive the car. So you should have your license on you. If you don't, I can run you in our computer to determine whether or not what you're telling me is true or not. If you don't have a license and you're driving a car, then I can arrest you, take you out of your car, and take you to the station. And again, all that takes place.
Does the fact that HPD, like other police departments across the nation, have significant staffing shortages contribute to your use or non-use of citations in lieu of arrest? Because we've heard this in group discussions with your department and with the Hawaii Police Department that, of course, arresting an individual takes an officer off of their beat, and if they had the option of citing an individual for something that they know is nonviolent, then they would prefer to not to do that.
I would agree with that because right now we have that ability to have discretion. I would also say that regardless of how staffing shortages we have and how short we are, I would never leave a member of the public in danger because, or a victim of a domestic abuse or a DUI person. No matter how short we are, that's our duty, that's our job to arrest this person and protect the public. By doing this citation thing, we're not protecting the public. You're creating bigger problems, although we would appreciate the ability to have discretion because, as you said, in a situation where, oh, you know what, I can give you a citation and it's okay to do that, I would give you a citation to alleviate any staffing issues that we might have. But regardless of staffing, it's our job to protect the public. So even if we were short, we would probably arrest if we, well, we would arrest if we have to.
All right, sure, please. Thank you, Chair. There were some real issues that came up out of COVID regarding citations for COVID violations, for mask mandates, for jaywalking. These are the kinds of things that we saw a real rise in citations for in the district courts. Do you think the Honolulu Police Department, like if we could kind of go back in time, would they have wanted to arrest people for these violations, or were you happy with the citations and the discretion that you had?
We're law enforcement. We basically do what you guys decide is the law. Not often we have a choice. A lot of times it's, we're supposed to do this and this is what we do. If we have an option and discretion, then again, depending on the situation, we'll go one way or another. To answer your question regarding COVID, would we want to arrest every person for that? That wasn't part of what the mandate said we could do. The mandate said we could cite. One. Two, if we could go back in time, COVID in the beginning was this real ominous thing where, you know, if we're going to put a bunch of people in a room together, it's not going to go well. And so in that scenario, we wouldn't grab a bunch of people and put them in a room together because, as you well know, the rules said that we couldn't do that at the time.
Okay, good. Thank you, Chair.
Okay, thank you. Representative Takayama, Vice Chair, please proceed.
Thank you, Major. While you're up there, like you said a couple times, right now you have the discretion to arrest or not arrest, petty misdemeanor, anything in that range. But I think I heard you saying that in the case of, even though it's a low-level petty misdemeanor, if that person cannot actually prove who he or she is, that out of an abundance of caution, you would prefer to arrest them, just so you could see whether there are an outstanding warrant or warrants or, you know, something else of that nature. Is that what I hear you saying?
I wouldn't say out of abundance of caution. I offer that information as part of the process that occurs when somebody gets arrested. And if you remove that part of the process, then things will start to fall between the cracks. Again, the current law has some criteria in place as to whether or not we would arrest or we cite. There's three criteria if you look, and I'm sure you know this, but you know, one of them is, let's see, I want to get it right. So currently, right now, without the changes, an officer may, but not need to, issue a citation in lieu of an arrest if the police officer finds and is reasonably satisfied that the person will, one, will appear in court at the time of the designated date that's on the citation. So that would go back to if I were to look into your past and figure that you've never gone to court, you've got 50.
But how would you look into this past if you don't know who he is for sure?
Well, that's even a bigger point. If I don't know who you are, then I'm left to guess if this passes to give you a citation with whatever name you give me.
So are you going to guess or are you going to arrest the person?
Well, are we post, pre, where are we in this discussion with this?
Right now.
So right now, would I arrest somebody for a petty misdemeanor? I have the option to either arrest them or I have the option to give them a citation. I would go through these three things here to determine whether you would meet the criteria for a citation or whether that's probably not a good idea, then I would arrest you for the petty misdemeanor. Does that answer your question?
I think so. I stop at the first one because the first one says you're reasonably sure this person will show up.
Yes.
You have no way of knowing.
We don't, well.
You're just looking at the person and you're guessing, right?
You're right. If we don't know who you are and we don't look at your record, then we just got to believe what you say. Which I would believe you in a room like this, full of our citizens here, but we don't always deal with people like us in this room. There are people that really don't want to play by our societal rules and stuff like that.
So what if I may, Chair, what I'm getting at, I guess bottom line is if we were to make it not discretionary, but mandatory that you issue citations for petty misdemeanors, you would still want to carve out where you could still arrest that person if you cannot know the identity of that person.
I would say yes.
Okay. Thank you. Thank you, Major.
Any other questions? Any other questions? Yes.
To the judiciary. Okay. Thank you, Officer.
Thanks.
There are several measures of success we're trying to determine here. One of which is criminality in the community, whether that's going up or down. And so we have several agencies following that. Office of the Attorney General. We have a new agency out of, new organization out of the Supreme Court. We have national data talking about all these things. Another way that we're trying to determine success is whether or not individuals actually appear to court. So does the judiciary keep data on the frequency with which individuals who are given citations make their appearances?
I would think that there may be a way for us to get that data through GEMS based on the input from the citation. So the citations are inputted at the district court level. We actually manually input those.
Another way to determine success is the completion of a case. So whether it's resolved, whether an individual is found guilty, not guilty, or they're transferred to another court for a mental health issue or for a variety of other reasons, like it's completed, right?
Mm-hmm.
Like the case is done. Does the court keep data on the completion of cases differentiated by those who are arrested versus those who are given a citation?
I would have to defer to the Criminal Justice, not the Criminal Justice Data Center, our newly formed Dr. Harbison's place to kind of figure that out. But I would think that we would be able to run some figures on that and determine whether or not the completions, once we get the completions cases, we could then go back and look at those and see whether or not they were issued a citation or an arrest.
Thank you.
Any other questions? Just, I have one question for the Major. If you could come back up again. So you appreciate your description about what happens under the current law. Is there anything that you think that the police would like to have to enable you to have more discretion in providing citations in lieu of arrest?
I think the discretion allowed to us now is working. If it, for some reason, I get there's a goal somewhere in here to get to this spot and we're trying to get there. I think where we're at now with this isn't part of that goal.
I recognize you don't like the bill. I'm just saying, setting the bill aside.
Okay.
You've already got some discretion under the law. You know, it's lawful for the officer to arrest. They may, but not need to, issue a citation in lieu of arrest with these, you know, various criteria. Is that sufficient, or do you want to have different criteria? Is there anything that you could see to improve it, setting aside what we've suggested in the bill?
Well, the bill suggests exceptions without any, what they are, these suggestions. You could outline, I mean, I guess right off the bat, our first exception would be abuse. Our next exception would be DUI. And
Well, I'm not talking about exceptions. Exceptions you need if it's a shall. Let's say it's a may, but right now you said, you know, you may but not need to issue a citation in lieu of the requirements of making an arrest. But then you've got a number of, you know, things that you're considering, that whether they're going to appear in court at the time designated, you know, outstanding arrest warrants, the offenses of such a nature there'll be no further police contact on or about the date in question or in the immediate future. Is there anything more that we should add to this to give you some guidance?
I think what's there is been working for us so far. I don't.
Is it working?
In my opinion, it is.
Okay, thank you. Kat, may I ask you to come up? From your experience, is it working? And would you provide them more discretion? The police?
Yeah, I understand. Well, I think the the jails are so completely overcrowded, we have created a real problem. And with the data that I cited, it's scary that we have so many people who are low-level offenders who would probably be better served in community treatment rather than in jail.
Okay. Okay, thanks. Mr. Lowenthal, could I ask you the same question, please? Setting the bill aside, what can we do to help get us in this direction without necessarily what we've suggested in the bill? But do you have another suggestion?
I think, just in listening to everybody, I think that the balance needs to be made between, if an arrest can be immediately made, how much time before that person can be released? I understand they can post a bond. I can understand they can get in front of a judge. But once a person's really in custody, once a person's arrested, and they don't have that money, and the charge is going to happen, the chances of them staying in custody until they are pressured to pleading guilty before their lawyer can even get there and have a meaningful conversation are really high. And I think that's a big concern, at least from the public defender's perspective. Once you have a person in custody and they are arrested, that changes the pace of representation, that changes the pace of the case itself. And so that is the big concern. The other part that's missing in all of this is that officers also release pending investigation after the arrest. Sometimes they don't have the time to put their case together and they let them go. And so this concern about there needs to be an immediate arrest in the front end seems to go away on the back end when it comes time to release them within, I believe, 48 hours if they don't have the case in place. So is it working is a very broad question, but the position of the Public Defender's Office is that the bill is intended to reduce the number of people who are being arrested and staying in custody. And I think that is a big factor in all of this. I hope that answers the question.
Okay. Go ahead, Representative Gannon.
To Mr. Lowenthal. Nobody testified before us who was a formerly incarcerated individual. Oftentimes, people who have been through the system, who have come out the other end and act as reformers, often come before this testimony, before this committee. How does the power dynamic change once a person is in custody? And what happens to the case that is different regarding their case if they were given a citation and given the opportunity to go before the court and face a trial and prospective punishment?
Certainly. I can only speak from my experience as a trial lawyer on Maui, but I think it is apt here, is that in the basement of the courthouse in Wailuku is the cell block. And in the cell block, you would get all the people who had been arrested. And our public defenders go into that cell block, meet our clients for the first time who'd been arrested, 48 hours, sometimes 24 hours. And the entire conversation is through a metal door, through a slit that is about the size of a candy bar. And they are asked, if you plead guilty now, prosecutor will agree to release you before you see any police reports, any discovery, anything like that. It's the deal that is on the table right now. The vast majority of the time, they're going to take that because it does not take long to lose everything with your rent, your housing situation, your job while you're in custody. The alternative is, if you're given a citation, public defender's office they will walk in. They will walk in and do an intake. I have a court date in 2 weeks. What do I need to do to prepare? It gives us a lot of lead time. And it is, frankly, a much more dignified and realistic way of assessing a case when a person is out of custody and has that kind of lead time.
Thank you.
Yeah.
Thank you. Any other questions? If not, thank you. Thank you very much to all the testifiers. Let's go on to the next bill. House Bill 1602 relating to criminal justice reform, and this bill authorizes a 48-hour grace period after a missed initial court appearance. First up, we have the judiciary.
Good afternoon again,
Afternoon.
Chair, Vice Chair. My name is Jennifer Owong. I'm the staff attorney for the criminal divisions for the First Circuit Court. The judiciary is not able to support this measure. We stand for the most part on our written testimony. I would point out that it's not the 48-hour grace period that is the real issue. It is the requirement that we be open and able to accommodate the defendant who fails to appear to show up at any time during that 48-hour period, and we have to basically stop whatever we're doing in order to accommodate, get a defense attorney, get a prosecutor, and take their case. As it stands right now, at least in the First Circuit, there's not a lot of times where a first appearance gets a bench warrant unless there's some other indication that either they've absconded or they're a danger or something to that effect. Generally speaking, we will continue it. A&Ps for felonies.
I'm sorry, rather than using acronyms, could you help me out?
Arraignment and plea hearings for felonies. I watch that. I've been a part of that calendar for at least 13 years. When somebody misses their arraignment on a felony case and they've bailed out, the judge does not issue a bench warrant. We continue it a week. We ask the public defender to get a hold of the bond company or to try and get a hold, if they have any information, to try and get a hold of that defendant and get them back into court within a week. So the judiciary would respectfully request that we be allowed to conduct our procedures in the way that we can and not just permit a defendant to show up at any time within that 48-hour period. We can continue it for 48 hours, we can continue it for a week, and they'll have notice of it because they can look it up online with their citation or with their court case, or they can contact their attorney. Unfortunately, I have to leave, so I will not be available for any questions.
Thank you for being here. Appreciate the testimony. Next, we have Mr. Lowenthal, Office of the Public Defender.
Good afternoon. The public defender strongly supports this bill, and I have to apologize. The testimony was meant to include an attachment. And I've been informed that you guys have received the attachment.
You got it, yes.
Very good. The attachment is designed to give an idea of how something like this would look. And so I think Hilo is a stellar example of when a bench warrant is issued. Individuals without an attorney can fill it out like a form, give it back to the court. It says right there on the form, you got 2 days to let your lawyer know when this case is back on track. So I do think that this is possible. You can have this grace period. There can be some sort of form in place so that the person who missed their court date can get it back on track. I just also want to add, kind of in response to what was just said, if there is a continuance, if there is a stayed bench warrant, which tends to be a practice on the Second Circuit in Maui, that is all at the discretion of an individual judge. And so we do applaud this bill because it attempts to make this a uniform practice. So we do support the bill. I am available for questions.
Thank you. Thanks very much. Next, we have Community Alliance on Prisons.
Good afternoon again. Kat Brady testifying for Community Alliance on Prisons in strong support of this measure. You know, I receive a lot of calls from people who, mostly women, who miss their court date because their kid was sick, the car didn't work, they had no transportation to the court. So there's a variety of reasons that people miss court dates, and they are not always intentional. Things happen in life, and I think we need to take that into account. So I included some of the laws that are in Hawaii, and we just really believe that people need to have time to breathe. The court needs to understand that people come from families and things happen in families and that are unintentional. You know, people get sick and they miss work or court dates, and we need to accommodate that. Thank you.
Thank you very much. Next, we have testimony from, let's see, we've received eight additional testimonies in support and 2 testimonies in opposition. Is there anyone else here that would like to testify on this measure, HB 1602? Yes, please come on up.
Good afternoon again, Chair, Vice Chair. My name is Wookie on behalf of the ACLU of Hawaii. We did not submit written testimony, but that was an oversight. In short, we strongly support this measure. And the perspective that I wanted to provide is on behalf of not just people who miss court dates because they lost transportation, but specifically the members of the community who are houseless. And in particular, from several clients that we represent and have represented, it becomes extremely problematic when they are told they need to come to court at a specific time, but given the difficulties in communicating with them, they sometimes don't get an update about how the court date was changed. And they show up in court and learn that, oh, the hearing was pushed off. And so it's really important that our system have some flexibility to account for, innocent and, we're not talking here about people who are willfully choosing to skip or abscond from court appearances. Of course, there are practical concerns, but as the Office of Public Defender explained, there are solutions to make this system workable, and so we request that the committee move this measure forward. Thank you.
Thank you very much. Is there anyone else wishing to testify on this measure? Wookie, if you could provide your name and information so we can keep that as part of the record, that'd be great. House Bill 1602, if there's no one else wishing to testify, questions, members? Representative Ganadin, please proceed.
Office of the Public Defender. Thank you so much for your exhibit.
Thanks.
I'm looking at the document now. Can you explain to the committee what ex parte means?
Sure. Without getting too buried in it, ex parte is just short for, it means a communication with the court without necessarily informing the other side. Now, it is a little bit of a misnomer because once it's filed online, the other side can see it. We still call it ex parte from the old days when you would file it, get it approved, and then give it to the other side. So that's all that means.
Okay. And this document that you provided to, let's say the court, it's only for the Third Circuit, which is Hawaii County.
Correct.
So is this document available to individuals here in the First Circuit?
It is not. We actually tried really hard to adopt that practice in the Second Circuit. This is, my understanding, it's an innovation that came out of the Hilo Public Defender's Office.
Okay.
Yeah.
And again, circuits are, although they are managed through the judiciary as closed, I guess, court systems, they're of course managed by the state, so they're implementing the Hawaii revised statutes.
Correct.
So would it make sense that there should be some uniformity across the circuits here regarding bench warrants?
Yes.
To your knowledge, how are continuances made in specialty courts?
So if you're referring to things like DWI court or drug court or that sort of thing.
So we have several specialty courts that the legislature and the judiciary has made. The judiciary gets some federal funding, actually, to do a variety of these courts. Drug court, which is very successful on Maui.
Right.
And on Hawaii Island, women's court, we have a veterans court. We've got emerging courts for juveniles. So how do they do it? What is the practice for continuing cases?
So for the specialty courts, the main thing that unifies the specialty courts is that the judge is far more involved with the defendant, so that if a person were to miss their court date, there would be like a team, so to speak, that would kind of give that sort of grace period. They would probably try to find out where that person is or what's happened and give a little bit of leeway, more so than, say, if that person wasn't in a treatment court. I hope that answers the question.
It does.
Okay.
It does. Would you say there's some differentiation in the courts that you have appeared before, because you've done
Yes.
up and down? Yeah. So,
Yes.
so is it depending on the judge and their experience? Judges don't like to be told that they're that they have discretion, even though they exercise discretion quite often. But like, what has your experience been?
It is judge dependent. It is dependent on the type of hearing. It depends on where you are in the case, which judge you have. Yes. And so it does run a gamut.
So this probably wouldn't apply to say important trial dates, like let's say a very important motion to dismiss, or a trial date in which you have members of the community there to hear evidence before a judge and all that kinds of stuff. So we wouldn't necessarily apply this 48-hour warning to, a major felony in which, the whole community is showing up to be there for it.
Right. I believe the spirit of this bill is to take care of the day-to-day, non-evidentiary hearings or status hearings. And again, this is the reason why you have uniformity. So for example, on Maui, you will have certain judges that require people to come physically to court for a pretrial conference. Maybe the only thing they're doing at that appearance is to confirm a trial date in a month. And so I think it is designed for those kinds of appearances.
So, and for, let's say a typical C felony, about how many of these pretrial hearings might a defendant have to come to or appear before?
For an out-of-custody Class C felony pretrial conference, it could be well over 20, sometimes even 30 before the case is resolved.
So 20 or 30 hearings in which the attorneys are arguing before the court. Sometimes the person is there, sometimes the person isn't there. Mainly about, let's say, evidence or who's going to show up, whether or not a jury should be there,
Right.
that kind of a thing.
Right. Yes.
Thank you.
Thank you. Any other questions? If not, thank you very much to all the testifiers. Let's move on to the next measure. HB 1603, relating to criminal justice reform. This amends various provisions related to pretrial release. First up, we have testimony from the Attorney General.
Good afternoon, Chair, Vice Chair, members of the committee, Deputy Attorney General Trisha Nakamatsu, appearing on behalf of the Department of the Attorney General. We do oppose this bill, although we understand there are issues with jail overcrowding and fairness in setting bail amounts. We believe the proposals contained in this bill are inherently flawed and fraught with risks. With regards to Section 3, attempting to estimate the amount of bail that an individual would be able to afford, the system seems to be entirely based on self-reporting, and the time frame for bail hearings, the information that would be available to prosecutors, it would be virtually impossible for a prosecutor to rebut anything that the defendant says about what their income is, particularly when a lot of jobs are paid in cash, and there's really no record available that we would be able to access. With regards to Section 4, it would be extremely unusual, we admit, for a court to deny release based solely on any of those enumerated factors on page 12, but it doesn't mean that it's impossible. It is entirely possible that there could be a situation where, based on those factors alone, and we presented a hypothetical in our testimony, but based solely on those factors alone, there could be very good reasons why a court might want to deny bail. Most likely it would involve a number of serious charges that the person is facing. We can't say for sure because again, it would be extremely rare and it's a hypothetical. But we don't want you to have to tie the court's hands and make them unable to do what they feel is right if and when that situation comes up. So we're available for questions, if any. Thank you.
Thank you very much. Next, we have testimony from the Department of Corrections and Rehabilitation and Support. Please come on up and introduce yourself and proceed.
Good morning, Chair, or afternoon, Chair.
Afternoon, yes.
Vice Chair, members of the committee. My name is Frank Young. I'm the Division Administrator for the Intake Service Centers, Department of Corrections and Rehabilitation. You have our written testimony. We do support the intent of the bill. I just offer a couple of comments. So in regards to Section 2, the distribution of bail reports, we do understand the need to have our reports, our information impactful for the courts. We do have, by statute, 3 days to get it submitted. So we do file through the electronic filing system, which then distributes it evenly. And then in regards to section, I think it's 4, but revocations solely based on a drug test.
5D.
5D, thank you. We are monitoring people on court-ordered conditions, so we kind of defer to the court's discretion. We will report violations, but I will say that if you limit us on monitoring or managing someone in the community based on a positive drug test, it could cause some issues. We would preferably like to work with someone to remain out in the community, but that's not always the case. So that's, again, we ask for the courts to have the discretion on that. So I thank you for the opportunity to testify, and I will be available for questions.
Thank you, sir. Next, we have testimony with comments from the judiciary. No. Next, Office of the Public Defender.
Hello again.
Hi.
Public Defender's Office supports this bill based on the written testimony. We do believe that this is a positive step towards reforming our bail system. I just want to speak into the most general terms on that. And I believe with regard to the revocation of bail or non-release or holding someone based on the, or preventing it from, say, the one positive drug test, I believe that this is actually a realistic look at what is already happening with pretrial services. I think by the time that they are making the motion to revoke bail, it tends to be more than one. But this just, again, is in promotion of uniformity and removing some of that discretion. So we do support this bill. Thank you.
Thank you. Next, we have testimony from the ACLU.
Good afternoon again. My name is Wookie Kim. I'm with the ACLU of Hawaii. Our organization provides comments on this measure. We do acknowledge that this bill really takes another significant step to reverse a different harmful norm in our criminal legal system, and that's the practice, the devastating practice within our pretrial system of forcing people in poverty who are accused of crime to sit locked up in a jail cell before trial. That norm that exists in practice is not how our system should be. As the Supreme Court has stated many decades ago, quote, "In our society, liberty is the norm, and pretrial detention is the carefully limited exception." So that principle needs to be effectuated in our pretrial system, and as we noted in our written testimony, we ask that this committee breathe life into this presumption of innocence and into this presumption that people should retain their liberty pretrial by making certain amendments. And they're noted in the written testimony, but in brief, this committee should clarify and add a presumption that a criminal defendant is entitled to release on recognizance pretrial. And similarly, the legislation should also clarify that the burden of proof lies with the prosecutor to show that a person should not be free pretrial. Because right now, the way our system works, effectively, a defendant needs to somehow demonstrate that they are, safe enough or not worthy of being held pretrial, and that's not how it should be. And then there's a couple other amendments we suggested, including clarifying that when findings are entered on the record, that is done in writing, because from our experience, oftentimes, even if a judge enters findings, they do it orally, and it's nowhere reflected either in an order or in the minutes, and therefore it becomes difficult to assess what underpinned a given decision that involves the defendant's liberty interests. So with those amendments, we believe that this bill would help unwind the truly inhumane system of wealth-based detention that exists in Hawaii today. And with that, I'm happy to answer any questions. Thank you.
Thank you very much. The only other person that said they'd testify in person would be Chris Caulfield. And in addition, we've received written testimony in support from 20 individuals and in opposition from 3 individuals. Is there anyone else wishing to testify on HB 1603? If not, questions, members. Representative Gannon, please proceed.
Office of the Public Defender.
Hello.
So this bill comes short of what other states and municipalities have done, which is essentially abolish bail, including Washington, Washington, D.C., and the entirety of the federal system. How does the federal government do it? Because the federal government has different ways that they assess whether or not an individual should be held pretrial.
That is correct. My understanding of the way the federal government does it is they completely reverse the paradigm. It would basically, they start out with an assessment with a presumption of release, and they have a factor-based analysis by pretrial services that then determine whether this individual should not be released. And so it kind of, it flips it. You start out of custody, and it's only if after they do the analysis, they make a determination that out of need for public safety or absconding, they make this determination. So it completely turns it on its head.
Does that affect the federal prosecutor's ability to pursue cases or federal judges' ability to see them to conclusion?
No. I think if you were to talk to most pretrial services officers, and I know the one here in Hawaii, I've attended conferences with her, they are the first to tell you that individuals coming back to court, even people that they didn't think would, tend to come back to court. Cases tend to be resolved in the same way.
All right, thank you.
Sure.
To your knowledge, what other communities have abolished bail? This is a long bill. This has got a lot of carve-outs. This does everything short of doing that. Do you know of any other communities that do that?
You know, off the top of my head, I think New York City has done a lot. I don't know if they've completely abolished bail, but I know they have for the majority of offenses. Yeah.
Thank you.
Yep.
Thank you. Any other questions, members? If not, thank you very much to all the testifiers. Let's go on to the next measure, 1604, relating to criminal justice reform. This allows the court to order substance abuse assessment and treatment, prohibits the arrest of a parolee or the revocation of parole solely due to the defendant having one positive test for drug use. First up, we have Mr. Lowenthal. You're getting a lot of exercise up and down. Thanks for being here. Please proceed.
The Public Defender's Office supports this bill. You know, in the discussion that we had, yes, parolees get revoked for very different reasons, and we do believe this bill is frankly, it's a modest step forward. It is to prevent the use of the positive test as a pretext for something else. So we do believe that this is a necessary bill, and we support it. Thank you.
Thank you very much. Next, we have testimony from Fred Hune. Thank you for being here, sir. Please proceed.
Afternoon, Chair Tarnas, Vice Chair Takayama, committee members. The Hawaii Paroling Authority opposes this measure, and we stand on our written testimony. And if there are any questions, I'm glad to answer, as well as any one of our staff here.
If you could highlight your reasons for opposing it for the people who didn't read your testimony that are watching online.
Well, one of the things is it combines pretrial measures as well as post-sentencing measures. And to have psychiatrists, psychologists do an evaluation before we could retake an individual who has violated the terms and conditions of parole, to me is unnecessary, long-standing, and the person has violated assigned terms and conditions of their parole. Now, there are other aspects where the person may be under investigation for a felony offense or domestic abuse, or we have received reports of an individual who has beat on their wife or their girlfriend or even a child. The police are conducting an investigation. We'll take them back. I mean, it needs to be expedited quickly for the safety of the public. You know, there are other specific things that are diverse because the crimes committed by a parolee are far and wide. But if there's an opportunity where the parole officer has allowed many, many times the individual, given them a break on dirty UAs, to go and seek treatment.
Sorry, dirty UA.
Dirty drug testing.
Okay.
Has proved positive for methamphetamine, cocaine, heroin,
Yes.
or even marijuana, then they will issue that warrant. Because how many chances and breaks can you give a parolee? So if I can cite other things, and if any of our staff is here to also attest
Sorry,
to that.
I just wanted you to highlight for those who are watching on TV. So
Okay.
that they could hear
Sorry.
what your thoughts are. That'd be great. Thank you very much.
All right, thank you.
Next, we have testimony from the Community Alliance on Prisons. Ms. Brady, please proceed.
Hello again. You know, I checked the numbers, and as of February 12th, there were 314 people in prison for parole violations. That's an outrageous amount of money. And that's in Hawaii and in Arizona. There's also 317 people who are in prison for probation violations. That's 16% of our population. I think we have to be a little bit more careful. Parole should actually be focusing on successful reentry, successful transition back to the community from somebody who's been locked up. It is scary to be released from prison after you've been in a while because you really don't know how to interact with the community. So I think if we had a parole board that actually focused on reentry, then we wouldn't have comments like, oh, the crimes that, you know, parolees commit are far and wide. I think we really need a parole system that focuses on helping people transition successfully to the community. Thank you.
Thank you very much. We've received written testimony in support from 7 individuals and in opposition from 9 individuals. Is there anyone else here wishing to testify on this measure? If not, questions, members. Representative Gannon, please proceed.
To Mr. Hune, the Parolean Authority.
Yes, sir.
Somewhat related to this bill, Vice Chair Takayama introduced a measure that we heard early in the session, which tried to, I guess, put forth a framework with, in which your office might end parole sooner for good time. End probation. Can you explain that process for us? Like or if there is a process?
Speaking strictly for parole,
Yeah.
if, for example, a person has a 10 or 20-year sentence or even a 5-year sentence, and we have them paroled, and they've demonstrated good behavior, law-abiding behavior, they can submit an application for early discharge. The parole board will take it up. Every month, we do administrative hearings, not in person. We'll receive the submissions for early discharge by the parole officers, who are the individuals who have firsthand contact of the individual's behavior in the community, and if warranted, we can conduct an early discharge and shorten their sentence. So it's been known that we have granted early discharges and released people after the 3rd, 4th year of incarceration on an open 5 sentence by the courts, or even on a 10-year sentence, we've reduced it and granted early discharge from 7 to 8 years from their sentence date. So they get their tail cut or the end of their sentence reduced by 2 years, and they're free in the community and have their civil rights restored.
We heard when we discussed that measure, somewhat pertinent to this, that the state of Hawaii has some of the longest terms in the United States. Do you know why that is?
Well, we attend the International Paroling Association every year. So we're in contact with Canada, UK, the states, other states, And Hawaii has indeterminate sentencing, one of 33 states with indeterminate sentencing, meaning once you're convicted, you're sentenced to 5 years, 10 years, 20 years, or an extended term to life. Now, the courts have also have certain discretions and have granted on an open 5 shorter terms such as 18 months, 3 years, or 2.5 years on an open 5 sentence, especially for dangerous drugs. So other states, you may have to do 20 on a life before you even consider it for parole. The parole board here sets minimums 6 months after the admission of an individual once they're sentenced by the court to determine what would be the minimum amount of time they would need to be incarcerated to complete programs before being considered for parole. So we have cases that come before us, the board, 6 months, and if they're a low level 1, we can see them within 2 years of their admission date, and if they've completed their programs, they'll be eligible for parole.
There's an emerging conversation, kind of in the government generally, about ways that we might better assist individuals who have had contact with the criminal justice system, moving them out of the criminal justice system and into treatment. There are efforts afoot by the governor. He wants to build things like Kauhale. There's several bills we move forward here through our health committee. Is your office in communication with any of those other state agencies, or say the governor's office on wellness and resilience?
Well, our acting parole pardons administrator did make contact with the Kauhale when they opened it up here, and whether it was suitable enough for any of our parolees. If there's a medical situation, it's a possibility. But it's a case-by-case thing. We can't just blanket whether they can qualify for Kauhale or not, because they are sentenced, they are in custody of the prisons, or they're under supervision of our parole officers.
Thank you.
Thank you very much. Other questions, members? If not, thank you very much to the testifiers. We're going to move on. House Bill 2342 relating to weapons. This prohibits carrying or using a firearm in the commission of a separate misdemeanor offense. It amends and clarifies prohibitions regarding deadly or dangerous weapons, regarding switchblade knives, and regarding butterfly knives. First up, we have testimony from the Attorney General. Welcome, Nick.
Hello. Thank you, Chair, Vice Chair, members. Nick McLean for the Attorney General. We support this bill, which is intended to revise and update state law regarding dangerous weapons, and there are really two main pieces of this bill. First, Section 2 of the bill focuses on the criminal use of firearms. This is an area of significant concern for the department. Currently, Section 13451B makes it a Class C felony to use a pistol to commit any crime. By moving this prohibition on the criminal use of pistols from Section 13451B into a new section, the bill is intended to clarify the law and to give greater notice in terms of what's prohibited. Additionally, the bill clarifies that this prohibition applies to all firearms, not just pistols. In Sections 3 through 5, the bill updates state law regarding dangerous weapons other than firearms. The bill provides several updates to Section 13451, which is the state's general deadly weapons statute. This law has actually been on the books since 1852, and a lot of the language in this provision really hasn't been changed since then. And so it's an effort to modernize aspects of that provision to help to increase clarity and facilitate enforcement. The bill also clarifies with respect to 13451, 52, and 53 that the focus of these prohibitions is really on the concealed carry of dangerous weapons in public and does not cover, for example, the simple possession of these weapons in the home. This is consistent with a very long history of restrictions on the concealed carry in public of dangerous weapons. This would also align the scope of these prohibitions with laws in a number of other states, including Oregon and North Carolina. In our testimony, we've suggested several amendments to the bill. We've suggested an amendment that would clarify that carrying one of these weapons concealed in a bag that's carried on the person is also covered by the statute. This has been an area of concern for law enforcement, for example, in the context of individuals carrying switchblade knives or butterfly knives onto commercial aircraft, which has happened in a number of instances, and is, of course, a concern for public safety. I also want to mention an additional suggested amendment at page 1, lines 10 to 11. We suggest removing the phrase "or intentionally use or threaten to use." We feel that removing this phrase would help to avoid any possibility of creating overlapping or redundant criminal offenses, which would help to also increase the clarity of this provision. As I noted, the department supports this bill. Thank you for the opportunity to testify, and happy to answer any questions the committee has.
Thank you very much, Mr. McLean. Next, we have the Office of the Public Defender. Oh, we got two of you.
Yeah, okay. Almost. Sorry, there's a communication mishap.
Wow.
The Office of the Public Defender opposes this bill for the reasons stated in the testimony. I apologize that it is late. There are the two main concerns are there is the concern that while these are amendments to existing statutes, it would appear to be covering, rightly or wrongly, constitutionally protected conduct under the Second Amendment, which is outlined in our testimony. I am available for further, to answer any questions about this. I'll just add that, we do recognize that, for example, the dangerous weapons does say within the home, but we do know from the Bruin case that that protection extends outside as well, and so that is the concern here. Thank you.
Thank you very much. Next, we have Hunter Alu, Major Alu, Honolulu Police Department. On Zoom, please proceed.
Good afternoon, Chair, Vice Chair, and committee members. HPD submitted written testimony in support of this bill. We support the bill's intent to clarify, update, and revise the weapons law, and also creating a new law carrying or use of a firearm and the commission of a misdemeanor. I'm available for questions. Thank you.
Thank you very much. Next, we have testimony from Todd Yukutake. At last.
Aloha, Chair.
Thanks for your patience.
Committee.
Please proceed.
Todd Yukutake. I provide comments for HB 2342. I have different positions on each part of it. One thing, as far as carrying a firearm in the commission of a separate misdemeanor, making it a felony, I know it's probably meant to address crime, but I'm concerned that it might affect licensed concealed carry holders who go through a background check and have to maintain lawfulness to carry. For example, playing fireworks is a misdemeanor. There's probably like 10,000 people playing fireworks on New Year's Eve, coming misdemeanors. But just because you're carrying a gun and playing fireworks, that singles you out as a felon for some reason. And, it's not related to the crime that they're committing. So that's why. I know it's a crime, but you know how it is with fireworks.
We're trying to change that.
Yeah.
Please proceed.
I support removing the ban on butterfly knives, switchblades, and batons, but we already have lawsuits addressing that right now. I oppose the ban on concealed carrying butterfly and switchblade knives in public. I don't think there's any reason to do so. I sent an email with a YouTube video yesterday that showing that there's no dangerousness with these types of knives versus other types of knives as far as drawing it from your pocket. So they're no more dangerous or deadly than other knives, kitchen knives or pocket knives and all those things. Actually, I do the gun rights stuff, and I talk to a lot of women concerned with self-defense, and a lot of them will actually pull out one of these knives from their purse, quite a few. And I tell them, hey, you don't know that they're banned in Hawaii? And they don't know that, but they carry it for self-defense. So it's a lot of women out there. It's not actually the men, it's quite a bit of women that actually carry it for self-defense. So that's why I don't think they should be banned, and for Second Amendment reasons also. Yeah, that's all I have. Thank you.
Thank you very much, Mr. Yukutake. Next, we have Marcus Tanaka on Zoom. Please proceed.
Oh, hello. My concern is with regarding the concealed carry portion of this law, for the butterfly knives or switchblades, things like that. No, basically what you're doing is banning it from leaving the front door. That's what it comes down, because how would I carry one of these knives without concealing it? I can't put it in my pocket, can't put it in a fanny pack. I can't clip it to my pocket because my shirt would cover it, which would now be making it concealed. So, that means I gotta walk around with it in my hand, but now is that not brandishing or some other crime that's being committed? So how would one leave the house? So I know you guys are trying to pass this law because of lawsuits, right? We change the law, lawsuits over, but instead of making it complicated, all you gotta do is say, hey, let's make these items legal, and that's it. If you want to carry it, as long as you're not, committing another crime, like, putting it, next to someone's throat or something, yeah, you can carry it, whatever. And like Todd mentioned, women carry it in their purse. I don't know if you know, but, like my wife's pants pockets are really short. She can't even fit a knife in her pants pocket. So it would have to go in her purse, and now she won't be able to carry one of these knives in her purse if she wants to. Thank you.
Thank you very much. Next, we have testimony from Michael Rice. Please proceed, Mr. Rice.
Aloha. I stand in opposition to the bill, at least as currently worded, mostly for the reasons expressed by Marcus and Todd. Basically, I carry a knife around, currently not banned, although depending on how this law is interpreted, it might be, as well as a baton for self-defense. Well, the knife not so much for self-defense. But my main concern would also be like, for when I eventually get my carry license. Now, if, say, I get stopped for speeding just because I have a pistol on me, does that now get bumped up to a felony? Just because I have a pistol, doesn't even have to come out, just, that poses a problem. Like I said, somebody gets caught jaywalking and, they happen to have a concealed carry permit. Is it now a felony? Even though, honestly, yeah, they shouldn't be doing that, but it happens. That's why they're considered misdemeanors, not felonies. Other than that, I stand on the rest of my written testimony. Thank you very much.
Thank you very much. Next, we have testimony from Alex Akui. Not present. We have testimony from about 12 other individuals, mostly in opposition, one in support. Is there anyone else wishing to testify on HB 2342? If not, questions, members? I have one question. Nick, if you could come up from the Attorney General's office. Now, you're not wanting to allow people to conceal this, but it's okay for them to clip it on their belt as long as it's visible.
That's correct. The goal is really to focus on the conduct that is of the greatest concern to law enforcement. As we understand, it's the use of, the concealed carry of these knives, and then, the reason why they were criminalized is there was a concern that they could be used, easily concealed and then, used to attack somebody based on that. So, no, as written, it would not cover the open carry, as you say, the having it on the belt buckle.
As long as it's visible.
That's correct.
That's legal to carry under this current
Under the current
proposed
law,
bill.
not under, yes, sorry, under
this
the
bill.
the bill, not under current law, yeah.
Understood. Okay, thank you. Thanks for that explanation. Other questions, members? If not, we'll move on. Thank you very much to the testifiers. House Bill 1927 relating to indecent exposure. This raises the criminal penalty for the offense of indecent exposure from a petty misdemeanor to a misdemeanor if the victim is less than 16 years of age. First up, we have testimony from the Attorney General's, Department of the Attorney General.
Good afternoon, Chair, Vice Chair, members of the committee, Deputy Attorney General Tricia Nakamatsu, appearing on behalf of the Department of the Attorney General. We do support this bill. We feel that it's appropriate for there to be a higher level of protection for children under the age of 16 who are intentionally exposed to another person's genitals in a manner likely to cause affront. Available for questions, if any. Thank you.
Thank you very much. Next, we have testimony from the Office of the Public Defender. Now we have Mr. Bento. Been waiting to hear from you.
Good afternoon.
I like to hear from Mr. Lowenthal, but it's good to hear from you too.
Thank you, sir. Good afternoon, Chair and Vice Chair, members of the committee. William Benta from the Public Defender's Office. Now, in regards to this particular bill, our office does oppose it, and it's a standard kind of opposition that we have whenever there's a attempt to increase the penalty for certain types of behavior. What's really concerning is the strict liability portion dealing with the age. I can understand the desire to create deterrence from a person purposefully exposing themselves to children. But when you make it a strict liability crime, then it kind of waters down that deterrent effect. Takes away from the fact that a person knows that they should not do something like that, but if they're going to get arrested and penalized anyway, they just disregard that. So that is one concern. The other concern is that, these are not necessarily situations where somebody is flashing children. I mean, I know that probably happens. But we see a lot of these cases occur where somebody is relieving themselves against a wall or in the bushes, and somebody gets a glimpse of something they should not see, and the police are called. Now, I'm sure the police can use discretion in that situation, but we see people be arrested in that. And, there are some individuals that have medical issues that make or require them to just have to go wherever they are because they can't find an open restroom. And so I'm concerned about those individuals as well being arrested and charged in this type of situation, especially with the strict liability as to the age. Thank you.
Thank you very much. Next, we have written testimony and support from the Hawaii Office of the Prosecuting Attorney, the Honolulu Department of Prosecuting Attorney, and 2 individuals. Is there anyone else wishing to testify on this measure, HB 1927? If not, questions, members. Representative Ganadin, please proceed.
To the Office of the Attorney General.
Yes, Rep.
Good afternoon. Hi. Can you explain to the committee the difference between indecent exposure as it is described as a petty misdemeanor versus sex assault in the 4th degree?
Sex assault in the 4th degree requires contact.
Okay. So you cannot...
It also, I'm sorry, one other thing is that indecent exposure has an added element of the actor's conduct is likely to cause affront.
Just is mere exposure affront?
No.
Okay.
Oh, I mean, I'm sorry. It completely depends on the specific circumstances surrounding the exposure, but just seeing someone's genitals in and of itself does not seem to classify without more.
So you have to basically ask somebody if they were affronted. Is that?
I believe there's different ways to ascertain.
Okay. How do you feel about the Office of the Public Defender's concern that this brings not juveniles, young people before the court in evidentiary hearings and potential jury trials, continuing to sort of add to the trauma of these incidences?
Well, I can't say what the department's official response would be, but I imagine that none of the prosecutors want to add to the trauma of a child, but at the same time, there's a balance between that and doing their duty to prosecute these cases for the general public safety and ultimately for the good of the child.
Is there a way to, after someone is charged with indecent exposure, to proceed with the case without bringing the child before the court or before cross-examination by a defense attorney?
You mean settlement?
Yeah.
Yes.
Do you think that settlement is easier as a petty misdemeanor or as a full misdemeanor? In your experience as a prosecutor, is it easier to settle petty misdemeanors or misdemeanors?
I'm sorry, I don't think I can really speak to that.
Okay, thank you.
Thank you.
Thank you very much. Any other questions? If not, thank you very much to the testifiers. Moving on to House Bill 2458 relating to the Department of Law Enforcement. This clarifies that the Director of Law Enforcement has authority to issue subpoenas as part of the investigative powers of the department. We have testimony and support from the Department of Law Enforcement. Welcome, Mr. Vincent. Please proceed.
Good afternoon, Chair Tarnas, Vice Chair Takayama, members of the committee. When Act 278 was passed, there's some things that were kind of left out. One of them was giving subpoena powers to the Director of Law Enforcement. So he currently has them, but only as it relates to the Narcotics Enforcement Division. And this bill basically just gives him the subpoena powers similar to a lot of other boards, commissions, and public officials. Thank you very much.
Thank you very much. Next, we have testimony from the Office of the Public Defender. Mr. Bento.
Good afternoon once again, Chair, Vice Chair, members of the committee. The Office of the Public Defender has some concerns regarding this bill. Let me just put it this way. When you see people called to Congress to have to testify, none of them ever show up without their attorney next to them. Now, most of those people are well-heeled and can afford to hire the best attorneys out there. We don't know who is going to be subpoenaed with this type of subpoena and what type of situation are they going to be required to testify in. But our office could not provide them with counsel if they're too poor to hire somebody for themselves. So they would be subpoenaed, and that strength of that subpoena brings them before whatever committee, tribunal, whatever it is, and then they're forced or compelled to give testimony regardless of the knowledge of their rights or the right to remain silent even, or to be counseled for that testimony. So for those reasons, we would oppose granting this authority and this power at this time. Thank you.
Thank you very much. Is there anyone else wishing to testify on this measure? 2458. If not, questions, members. Representative Ganadin, please proceed.
Office of the Public Defender. Sorry, Mr. Bento. I don't even know this answer to this question. Are individuals who are subpoenaed by the state Mirandized? And can you explain to the committee what Mirandized means?
Well, I think it depends on the situation. So if a person is subpoenaed, which I think most of us understand that to mean we're ordered to come to court to give testimony. So that's a subpoena that's issued by the court. An attorney, prosecutor, deputy public defender can make a request of the court to issue such an order to compel someone to come to court and to give testimony. They're not Mirandized before they give testimony. But the court has a duty and a responsibility, and I think somewhat the attorneys as well, as long as it doesn't create a conflict of interest, to inform the court if there's a belief that someone might be giving evidence against themselves in a certain circumstance.
Thank you.
All right.
Thank you. Any other questions, members? If not, thank you very much to the testifiers. Next up, we have HB 1869 relating to unmanned aircraft, establishes the felony offenses of misuse of unmanned aircraft in the first, second, and third degrees. On this measure, we have testimony from the Department of Corrections and Rehabilitation. Thank you for your patience. Director Johnson.
Good afternoon, Chair, Vice Chair, members of the committee. I'm Tommy Johnson, the Director of the DCR, Department of Corrections and Rehabilitation. I'll make it brief. We support this measure. We did, though, recommend some amendments to 3 sections, which is listed on page 2 of our testimony, to mirror Senate Bill 2194 SD1, the companion measure, to add in correctional officers and correctional workers to each of those sections. Thank you. That was your question. That's all I have.
Thank you. I appreciate your testimony. Next, we have testimony from the Honolulu Department of the Prosecuting Attorney. Welcome. Please proceed.
Thank you. Good afternoon, Chair, Vice Chair, and committee members.
Wilson Ung on behalf of the Department of the Prosecuting Attorney's Office. The department is in strong support of HB 1869, the purpose of which is to establish offenses in the state of Hawaii addressing the increasing public safety concerns presented by unmanned aircraft, also known as drones. While the FAA does have regulations with regards to misuse of drones, as indicated in the submitted testimony, state and local law enforcement agencies are often in the best position to deter, detect, immediately investigate, and as appropriate pursue enforcement actions to stop unauthorized or unsafe drone operations. Because many consumer drones can be controlled from great distances away from the operator, it is often not possible for law enforcement to locate or identify the person operating a drone. It would make sense for these types of activities to be strongly deterred. And also, drones can inflict a great deal of injury or transport contraband materials beyond what most people would be capable of doing themselves. In order to, also noted in the submitted testimony is the potential of preventing any possible obstructions to HFD, the Honolulu Fire Department crisis investigations. For those reasons, the department is in strong support, and I'll be available for questions.
Thank you very much. And finally, we have testimony from Michael Rice on Zoom. Mr. Rice, please proceed.
Aloha again. I mostly just have comments about the bill, a few concerns, mainly about the electric gun portion, firearms. I understand, yeah, you know, you've probably seen the video of the guy duct taping a Glock to a drone and just having it fire off in the woods somewhere, and that is concern. But there's, like, if this bill were to pass unamended, it would prevent, like, developers from making new inventions, not new inventions, but making new technologies that can be used by, say, HPD. Like, you know, we've seen many of the drone footage coming out of Ukraine where they basically just, well, they do more than duct tape a grenade to a drone, but they make it so they can deliver the grenade where it needs to be. That can be altered for, you know, police use. They can, instead of a, you know, fragmentation grenade, they can use a flashbang, smoke grenade, you know, literally a flying taser to try and subdue the suspect without putting police officers at risk or the public. So, and typically, the only people that would be exempted from this bill as stated would be the police or government agencies. And a lot of these technologies do not come out of government labs. They come from, for the most part, private individuals such as myself who would tinker with these things and then would go sell the idea to the police, maybe make a production model. And so I'd like to see at the very least the electric gun portion removed, because that's basically a taser. And if somebody's gonna misuse a taser with a drone, I'm pretty sure there's already existing laws that can be applied to that. And well, the same thing would be with applying to firearms, because if I wanted to develop basically an airborne shotgun to shoot less than lethal rounds for HPD, I would be prevented from doing that. Because even if I only fire beanbag rounds, it would still be considered a firearm. Thank you very much. Other than that, I stand on my written testimony.
Thank you very much. Is there anyone else wishing to testify on HB 1869? If not, questions, members? Nope. Thank you very much. We'll move on to the next measure. 1870, relating to crimes against elders. This establishes strict liability for crimes against elders with respect to the attendant circumstance that the victim was 60 years of age or older. First up, we have testimony from the public defender. Welcome, Mr. Bento. Please proceed.
Thank you. Good afternoon again, Chair, Vice Chair, and members of the committee. Our office does strongly oppose this bill, as outlined in our written testimony. We do believe that the strict liability portion, whereby the government's not required to prove that the defendant knew the person was, or strongly suspected that the person was 60 years of age or older, creates a host of issues that we've outlined in our written testimony. But, you know, the reason why this law was passed in the first place to create this protected group was to deter people from targeting people 60 years of age or older. By making it strict liability, you're kind of undoing that. to prevent people from targeting certain groups or individuals. It also, as we outline in our written testimony, it flies in the face of our model penal code, whereby the mens rea, the state of mind that a person must possess in committing a crime, goes to each and every element of the offense. And in this case, it would go to whether the person is 60 years of age or older. And so we would just ask the committee to take a hard look at this and other bills like it dealing with strict liability. Thank you, and I'm available for questions.
Thank you very much. Next, we have testimony from the Honolulu Department of the Prosecuting Attorney. Welcome. Please proceed.
Aloha mai kākou, Chair, Vice Chair, and members of this committee. My name is Chad Au, and I'm here on behalf of the Department of the Prosecuting Attorney's Office. Our office strongly supports this bill. We strongly support the purpose of this bill by removing the requirements that a perpetrator knew or reasonably should have known the age of the victim. As we currently stand in 2021, when this legislature passed House Bill 490 and made into law Act 147 to protect Hawaii's older population from being targeted from certain crimes. As a portion of this law, the language to known or to reasonably have known to the age of the victim was deemed an appropriate safeguard to protect the rights of perpetrators and would-be perpetrators. Unfortunately, in practice, this language has taken much of the effect out of Act 147. Because of one's perception of someone being the age of 60 or older can vary from person to person. It's difficult for prosecutors to consistently prove this requirement, particularly when we have to prove this to all 12 jurors in a jury trial. Nevertheless, the department strongly believes that victims who are in fact 60 years of age or older deserve the added protections. By removing the requirements that a perpetrator knew or reasonably should have known that a victim was 60 years of age or older removes any guesswork for any jurors, any prosecutors, or anyone determining the effects of the law. It also adds the protections that our elderly community deserves. Thank you for the opportunity to testify, and I'll be around for questions.
Thank you very much. Next, we have testimony from the Honolulu Police Department. Major Hiramoto. Please proceed.
Hey, good afternoon. This is Captain Thomas Chang from the Criminal Investigation Division. I'll be representing HPD on behalf of Major Hiramoto. Can't make it today. But HPD supports this bill, and we stand by our written testimony. The reason is this bill strengthens HPD and the prosecutor's office to combat criminals who victimize our kapunas in our community. So we strongly support this bill. I'll be here to answer any of your questions. Thank you.
Thank you very much. We have one more testifier said they testify at Sandy Wong. Please proceed, Sandy Wong.
Yes, Chair. My name is Sandy Wong. As you know, I'm usually before the committee representing companies as a lobbyist. Today, I'm representing myself in my personal capacity, but more importantly, I'm representing myself, Sandy Wong, as kapuna. Last June, I was assaulted in my neighborhood by a juvenile. I called the police. When my case went to the prosecutor's office, the prosecutor attempted to use the kapuna law because at the time of the assault, I was 62 years old. But then when he looked at the body camera, he called me and he said, I'm not quite sure we could convince everyone that you were 60. Now, in one sense, I was flattered because he didn't think I was 60, but, I was 62 years old. And it really disappointed me that as a vulnerable kapuna, that suddenly I wasn't protected by this law. And it seems that it's so subjective. Some people might look at me one day and go, oh, Sandy looks 59. But another day they go, oh, Sandy doesn't look so good today. She looks 65. So I think strict liability is very important, and I urge you to pass this bill out for all of us kapunas, whether we look good or we don't look good. Thank you.
Thank you very much. We've received written testimony and support from 9 individuals and organizations. Is there anyone else wishing to testify on HB 1870? If not, questions, members. Seeing none, even from the two kupuna up here.
Oh, is that right?
He can't tell, right? He can't tell. Okay, okay. Point well taken. Next, let's move on to the next measure. HB 2748, relating to law enforcement. This establishes statewide vehicular law enforcement pursuit policies. And first up, we have Michael Vincent, Department of Law Enforcement.
Good afternoon again. Department of Law Enforcement submits comments on this. You know, the Law Enforcement Standards Board in Chapter 139, they're not given specifics. They are actually tasked with coming up with standards for our law enforcement agencies to follow. And this bill kind of, you know, is now getting into, you're going to do all of these separate things. And so just from that point alone, it's kind of off base. But the real problem here is every law enforcement agency, and I haven't read the policies of our county law enforcement partners. I have seen ours, and ours is in compliance with the Commission on Accreditation for Law Enforcement Agencies and the International Association of Chiefs of Police. And I suspect that our county law enforcement agencies, their pursuit policies are likewise consistent organizations that are issues that come up when there are police chases or pursuits and something happens. And you know, the policies are there. And I think that if we don't need to legislate the policies because the agencies are already, and I'm confident the county agencies are just as, if not better than our pursuit policy. But the issues dealing with whether a pursuit occurs and what happens during that pursuit or following a pursuit are probably things that should be resolved between the agency and those that are involved with those, rather than trying to legislate something that is already in place with the agencies. Anyway, thank you very much.
Thank you very much. Next, we have testimony from the Honolulu Police Department. Thank you for your patience, sir. Both of you.
Good morning, Chair, Vice Chair, members of the committee.
It's afternoon now. Sorry, we
sorry.
really kept going. I know we've been at this a while.
I know. Aloha.
Sorry.
Aloha.
Please proceed.
Major Stason Tanaka of Honolulu Police Department's Traffic Division. We are in opposition of this bill, and I'll summarize my sentiments for those who might not be familiar with it and who actually care what I have to say. We're opposing the proposal to establish the statewide vehicular pursuit policy because we feel that each county should be left to independently draft a policy based on their specific needs, taking into consideration their training curriculum, available equipment, as well as their unique geographical layouts and communities. As it stands, each county also has its own police academy with a curriculum based on their county's needs. I'll be happy to answer any questions.
Thank you. Appreciate that. Next, we have testimony from the State of Hawaii Organization of Police Officers and also from the Policing Project at New York University School of Law. Is there anyone else wishing to testify on HB 2748? If not, questions, members? Representative Ganadin, please proceed.
To the Major with Honolulu Police Department.
Sir.
There have been a lot of community concern about police pursuits here on Oahu. The most recent one being the one that happened on New Year's Day, that happened through what felt like every street and highway here in Honolulu. Was that, according to your training curriculum, that pursuit?
Was that a pursuit?
Yeah. It's been in the media pretty often, actually.
Yes.
That your captain might not have approved so many officers chasing one individual.
Yes. So to answer your question, the short answer is yes. But the second part to that answer is it still needs to be reviewed for justification. So that incident will go to a pursuit review board, and it'll be looked at and compared with our pursuit policies and practices, and then it'll be determined if it was a justified pursuit or not.
How many officers were involved in that pursuit?
I can't tell you offhand how much, but it was multiple, as you.
Would it be fair to say over 10 vehicles?
I'm not sure, but from what I heard that was posted on Facebook, it was multiple, like 10 and over vehicles.
All right.
From what I've heard.
And then I'm sure you're aware of also the incident which happened in which individuals are saying that they were unfairly, I guess, detained and assaulted by officers as a result of this chase. So you're aware of this as well?
Yes.
Okay. So is that discussed in the training curriculum? I mean, because it seems like that might have been a pretty significant, not only violation of these individuals' civil rights, but I'm not sure how that incident and this hours-long incident comports with the training curriculum.
Yes, so going to that incident you're mentioning, because of the criminal allegations, it is going to be reviewed by our professional standards office, and they will be reviewing those allegations and investigating it.
In the last, let's say, 5 years, do you know how many lawsuits have been filed against the Honolulu Police Department for pursuits?
No, I don't.
All right. Okay. Would it be fair to say over 10, under 10?
I can't really say because I'll be honest, I don't know.
Okay. All right. Thank you, officer. Thank you, Major.
Thank you. Any other questions? If not, thank you very much for your testimony.
You're welcome.
Let's move on to next bill, House Bill 2581, relating to emergency management. This removes the ability for a mayor or the governor to suspend electronic media transmission during a state of emergency. We have comments from Hawaii Emergency Management Agency. We have testimony in support from Hawaii County Council member Ashley Kirkowitz. We have testimony in support from Hawaii County Council member Susan Lee Loy. Testimony from Chris Leonard in support. Mr. Leonard, please proceed. If you could unmute yourself, that'd be great.
Help. Sorry, it's been a long day for all of us, I guess. Good afternoon, Chair Tarnas, Vice Chair Takayama, and committee members. My name is Chris Leonard, and I am the president of the Hawaii Association of Broadcasters, in addition to the president of New West Broadcasting, a Big Island Radio Group, and chairman of the Hawaii State Emergency Communications Committee. We are in strong support of HB 2581 as it addresses a threat to public safety and fixes an unconstitutional provision in HRS 127A. While we understand the need to grant additional authority to the governor and mayors during state of emergency, 127A currently grants unnecessary and unconstitutional and unwarranted additional powers that pose a threat to public safety. As it's written, the governor and or mayors may exercise the following additional powers. They can shut off water mains, gas mains, electrical power connections, and to the extent permitted by or under federal law, suspend electronic media transmission. There are numerous issues with the statute, including jurisdictional issues. I'm unaware of any federal law that grants this authority to the state or county level. However, there are multiple federal laws, including the Integrated Public Alert and Warning System Modernization Act of 2015, Executive Order 13407, and others that mandate very specific requirements to ensure that, quote, under all circumstances, the president can communicate with the American people. Furthermore, Section 11.51 of the Emergency Alert System Code requires that analog and digital broadcast stations, radio and television stations basically, must transmit national level EAS or emergency alert system messages. And a state or county suspension of broadcast feeds would prohibit our ability to be compliant with federal law and put the public at risk. The language also grants a blank check to shut down electronic media without providing for why this would be necessary, what systems, and for how long. And electronic media potentially includes radio, TV, internet, cable, cell service, text messaging, social media, et cetera. The language, we've done a little bit of research. The language is based on a repealed civil defense air raid law from 1951 that provided power to the governor during air raids. It may have been practical in 1951 to keep our enemies from using radio signals to triangulate coordinates to attack, but seeing how you can navigate your way to a square inch on your iPhone today, it serves no purpose in today's world. Chair Tarnas, you've heard us talk about this in the past, and we appreciate your support. I'm a firm believer that I, as a broadcaster, and you as elected officials and our emergency managers are bound by a common thread. We all have a duty to serve the public interest. We're committed as broadcasters to meet these obligations, but 127A needs to be revised. It's a simple edit that we have proposed, and it would allow us to continue to deliver potentially life-saving information and keep our communities informed during a state of emergency, which is clearly a time where we need more, not less communication. And with that, I'm available for any questions that you may have.
Thank you very much. We've got two other testimony in writing and support. One's from the Grassroots Institute of Hawaii, the other's from individual Andrew Crossland. Is there anyone else wishing to testify on this measure? If not, questions, members. I have one question. Mr. Leonard, in the testimony from the Hawaii Emergency Management Agency, he states that HIEMA made significant progress on last year's HB 522, HD1, SD1, with input from various stakeholders who supported and agreed on compromise language. We believe it is important to reference the previous bill in order to fully understand the potential impact of the current revision. Referencing last year's bill is crucial as it provides a foundation for building upon existing agreements and compromises. Have you been part of those discussions and coming up with a compromise?
So we were part of the discussions. Last year's bill, HB 522, made it to conference committee, but it was assigned to conference committee about 15 minutes ahead of the 24-hour or 48-hour deadline and didn't receive a conference meeting. However, the HB 522 HD1, SD1, the language is the same. So we had discussed compromise language with HIEMA and had some discussions about things that we thought would address some of our concerns. But that language never made it into the HD1 or SD1 bills. And I actually had some opportunities to reread that and review that while I was waiting for this bill to come up here. So the existing language, while there were discussions that were productive, the language that we had discussed never made it into any of the bills. And because this had gone to conference committee on the carryover, it was not likely, procedurally, it's not likely that those conference committees are reconvened. And a new bill was submitted this year, both on the House and the Senate side.
Okay, and the language in this bill is based on that bill as it left the House?
Yeah, if you look at the HD1 and the SD1, I believe the language is identical. The compromise language that was discussed did not make the HD1 or SD1 bill that was forwarded to conference.
Okay. If this committee decides to move this on, it'll and the House decides to approve it, it'll go over to the Senate, and then I think I'm hoping that HIEMA would make any recommendations that they'd like to make, because their testimony did not include amendments. So I'm not sure what they were referring to.
We're continuing to have discussions. I mean, the one thing I will say is that I think that we share as broadcasters similar concerns that HIEMA has, and that is an obligation to make sure we keep the public informed. They want to make sure that they are able to move and do what they need to do under a state of emergency for our membership, for our broadcasters. We want to make sure that we can continue to keep people informed. And if you look around the country, if you look at the Paradise fires in California, you look at Katrina, and more recently, if you look at the tragedy in Lahaina, it's clear that more communication, not less, is absolutely critical, and anything that potentially stands in the way of that, aside from being against law, aside from potentially being a violation of the First Amendment of the Constitution, is just a danger to public safety, and we want to make sure that we can do everything we can to keep the public informed.
Okay, well, if this bill does move forward, I would just urge you to have further conversations with HIEMA and see if we can come to some agreement.
We shall, and I saw their testimony was submitted late. I saw that while I was waiting for this, and I will have a follow-up conversation with them as
very good. Thank you. Any other questions, members? If not, thank you very much to the testifiers. Let's move on. House Bill 2184 relating to campaign finance. This bill would prohibit contributions from persons convicted of various campaign finance, lobbying, and ethical offenses. It redirects the unlawful contributions to the Campaign Spending Commission. First up, we have testimony from the Department of the Attorney General. Welcome. Please proceed.
Good afternoon, Chair Tarnas, Vice Chair Takayama, and members of the committee. Deputy Attorney General Candace Park, we've pointed out our concerns with subsections A, C, D, and E in our written testimony, and I am available for questions. Thank you.
And you've suggested some amendments.
Yes, sir.
Okay, great. Thank you very much. Next, we have testimony from the Campaign Spending Commission. Gary Cam, please proceed. Mr. Cam, are you available?
Yes, I am. The commission supports the intent of this bill, and we have some comments. First of all, we agree with Deputy Attorney General Park's comments, and the commission would like to point out that in subsection A, the commission does not believe that the prohibition, the ban on contributions can be implemented fully. And the reasons for that is because in Chapter 84 and in Chapter 97, the remedies in there are basically just civil in nature. And I don't think we'd ever get a conviction in either statute. And in subsection C, commission believes that the depository institution should be specifically tied to a candidate committee's account. I mean, since this is being placed in Chapter 11 in the campaign finance law, and also it might be better to have the surplus funds be returned to contributors within 30 days, and then this sheet would kick in. That would probably be less objectionable to have monies going back to contributors. Thank you.
Thank you very much. And we've received 3 written testimonies in support from 3 individuals. Is there anyone else wishing to testify on House Bill 2184? If not, questions, members? Seeing none, we'll move on. Thank you very much to the testifiers. House Bill 2072 relating to campaign finance. This requires certain solicitations that reference disasters to include a disclosure and deems violators guilty of a Class C felony. First up, we have testimony from Gary Cam, Campaign Spending Commission.
Good afternoon again. Commission supports the intent of this bill also, and we offer just one comment. To make it clear, well, the commission believes that deceptive solicitations of contributions should be not allowed. And to make it clear that solicited contributions are covered by the campaign finance law, the commission recommends that person on page 1, line 5, be deleted and replaced by candidate, candidate committee, or non-candidate committee. Thank you.
Thank you very much. Next, we have testimony in opposition from the Office of Public Defender. Mr. Bento, welcome.
Thank you, and good afternoon once again, members of the committee. Our office believes that what is hoped to be accomplished by this bill is already in force in our theft statutes. We do understand that there may be the feeling of a need to have something labeled relating to campaign finance, but our theft statutes already, we believe, cover this type of fraud. Our suggestion would be that if there's a feeling it's necessary to have a particular area of the law cover campaign finance, that perhaps we amend the theft statutes to include a section that deals with campaign finance fraud. That way it's not confusing to the public. And I do also feel that people pay attention more to what is theft and what is not theft as opposed to how you properly run a campaign, because the majority of us will never be involved in that kind of situation. I do understand that there could be, individuals out there that try to raise funds fraudulently by claiming they're going to run for office or that they're going to use the funds to support a certain candidate. We know that those things do occur, but again, you can prosecute those under the theft statute. So to be consistent, as an alternative, we would ask perhaps to amend the theft statutes, and I'm available for questioning. Thank you
very much. Anyone else wishing to testify on House Bill 2072? If not, questions, members? Seeing none, we'll move on. Thank you very much to the testifiers. Our last bill to take testimony on this agenda is HB 2470, relating to contested cases. This clarifies that a contested case hearing is not required when a tribunal has already issued a final decision and order in a substantially similar contested case proceeding that was not appealed, or where a court of last resort has already issued a final decision on the proceeding or on other substantially similar matters. First up, we have testimony from the Department of Land and Natural Resources. Mr. Hirokawa, welcome. Please proceed.
Thank you, Chair Tarnas, members of the committee. Ian Hirokawa with DLNR. Just quickly go over, summarize our testimony. We're in support of this bill, and we want to note that what it does, it really just takes the well-established, long-standing principles that apply to, essentially what we may label as frivolous litigation and applies them to contested case proceedings under Chapter 91 HRS. So it's not necessarily changing, what's already there. It's just simply applying the same standard to the contested case proceedings. And I'll be available for any questions. Thank you.
Thank you very much. Next we have, would Mr. Tsuji want to testify separately?
I know he left. I'll be available for questions, Chair.
You're available for questions? Thank you, Mr. Tsuji.
Yes.
Next, we have testimony from the Life of the Land. Henry Curtis? Not present. Testified with comments. Next, we have testimony from Isaac Moriwaki, Earth Justice. Welcome. Please proceed.
Good afternoon, Chair, Vice Chair, members of the committee. We submitted testimony in opposition to this measure. Largely stand on our testimony, available for questions. In brief summary, yes, we oppose this bill because, one, it's already covered under established Hawaii Supreme Court's precedent. It's not clear what further this bill seeks to accomplish. And the bill language itself is poorly drafted, it's ambiguous, overbroad, and it's probably going to cause way more problems than it's attempting to resolve. And again, I'm not clear what it's trying to resolve. Thank you very much. Available for questions.
Thank you very much. And finally, we have testimony in opposition from David Kimo Frankel. Anyone else wishing to testify on HB 2470? If not, questions, members? Seeing none, thank you very much to the testifiers. We're going to go ahead and go into decision-making. Back at the top of the agenda. Okay, first up, House Bill 1601. This bill needs more work. I'd like to defer it to till February 28th and put it on the agenda for decision-making at that time. We're going to try to work out amendments to the bill to address the concerns that came in on the testimony. House Bill 1602, I would like to defer this also to February 28th. And again, work on this one to try to address the concerns that came in testimony and bring it up for decision-making on the 28th. House Bill 1603, on this one, I think this needs a lot more work. So I think we're just going to defer this measure. I appreciate the work that's been done on it. I introduced it because we need to move the conversation forward. But we're just going to need to work on this some more. So I recommend we defer 1603. 1604, I recommend we move this out with technical amendments and defect the effective date to the year 3000. I think it is a useful bill and does move us in the right direction. Questions or concerns, members? Yes, Representative Holt.
Thank you, Chair. Last year I gave a personal story about how I think that this bill is unnecessary and it helped somebody in my family that the drug test put him in jail. So I will be voting no on this measure.
Understood. I appreciate that. Thanks. Any other questions or concerns, members? Yes, Representative Ganadin.
Thank you, Chair. I think that the conversation continues to evolve as to how to treat those who have addiction issues, not just here in the building, but in the community. We are starting to use different vocabulary, different languages, And we're seeing a lot of collaboration between state agencies, nonprofits, organizations to that effect. So I think this bill moves us in the right direction. Thank you.
Thank you. Any other questions or concerns? If not, let's move out HB 1604 with amendments.
Voting on House Bill 1604 with amendments. Chair and Vice Chair vote aye. Representative Evslin?
Aye.
Representative Ganadin?
Aye.
Representative Holt?
No.
Representative Ichiyama excused. Representative Iligan?
Aye.
Representative Kong excused. Representative Miyake?
Aye.
Representative Souza? Excused. Chair, your recommendation is adopted.
Thank you. Moving on, next bill 2342. I recommend that we move this out with amendments. I'd like to take the Attorney General's amendments and make technical amendments for clarity, consistency, and style, and defect the effective date to the year 3000. Questions or concerns, members? Not, Vice Chair, for the vote.
Voting on House Bill 2342 with amendments, noting the excused absences of
Oh,
representatives.
wait. Sorry. Sorry, I have to make some additional amendments, sorry. I just was reminded. On page 1 of the bill, lines 10 to 11, I'd like to remove the phrase "or intentionally use or threaten to use." These are recommendations from the Attorney General that did not make it into their testimony that came in afterward. And then on page 1, line 12, a new subsection D could be added to section 2, which would read, "The term misdemeanor does not include a petty misdemeanor." So those are the additional changes, all coming from the Attorney General, but those 2 additional ones came after the testimony came in. So with those changes, I recommend we move them out with amendments.
Voting on House Bill 2342, passing with amendments, noting the excused absences of Reps. Ichiyama, Kong, and Souza. Any reservations or noes? Your recommendation is adopted.
Thank you. House Bill 1927, I recommend we move this out with technical amendments and defect the effective date to the year 3000. Questions or concerns, members? If not, Vice Chair, for the vote.
Voting on House Bill 1927 with amendments. Any reservations or noes? Reservations for Representative Ganadin. Chair, your recommendation is adopted.
Thank you. House Bill 2458, relating to the Department of Law Enforcement. I recommend we move this out with technical amendments and defect the effective date to the year 3000. Questions or concerns, members? If not, Vice Chair, for the vote.
Voting on House Bill 2458 with amendments. Any reservations or noes? Recommendations adopted.
Thank you. On House Bill 1869, on this measure, I recommend we move it out with amendments. I would like, on page 4, line 8, we should add the words transport and before the word introduce. So it'd be transport and introduce, page 4, line 8. And then I would also like to adopt the recommended amendments from the Department of Corrections and Rehabilitation in their testimony. And defect the effective date to the year 3000. Questions or concerns, members? If not, Vice Chair, for the vote.
Voting on House Bill 1869 with amendments. Any reservations or noes? Recommendations adopted.
Thank you. House Bill 1870, relating to crimes against elders. I recommend we move this out with amendments to defect the effective date to the year 3000. Any questions or concerns, members? If not, Vice Chair, for the vote.
Voting on House Bill 1870 with amendments. Any reservations or noes? Reservations for Representative Ganadin. Your recommendation is adopted.
Thank you. On the next bill, House Bill 2748, relating to law enforcement. On this, I recommend we move it out with amendments. On page 2, lines 2 and 3, I'd like to amend that to align with the statutes relating to assault. Page 2, line 15, I want to remove the language from page 2, lines 6 to 7, not line 15, on page 2, lines 6 and 7, we're removing some duplicative language, and the language is, G, the offense of operating a vehicle under the influence of an intoxicant under section 291E-61. So we'll remove that. Page 3, line 8, adding the word reasonably between officer and believes. Page 6, lines 17 to 19, I want to delete the language and replace with a new definition of vehicular pursuit, which would be an attempt by a law enforcement officer in an authorized emergency vehicle to stop a moving vehicle where the operator of the moving vehicle appears to be aware that the officer is signaling the operator to stop the vehicle, and the operator of the moving vehicle appears to be willfully resisting or ignoring the officer's attempt to stop the vehicle by increasing vehicle speed, making evasive maneuvers, or operating the vehicle in a reckless manner that endangers the safety of the community or the officer. On page 6, line 9 to 10, I want to delete section E, replace with, quote, language from policing projects I want to replace it with some language from the policing project's testimony relating to reporting of data relating to pursuits. We've got this testimony from the policing project. Page 6, I want to add new language, quote, no later than 3 months before the act goes into effect, the Department of Law Enforcement shall adopt rules for the collecting and reporting of data required under this statute pursuant to HRS Chapter 91. Ignore that one. And then I would also like to use the term law enforcement vehicle and define that term to mean a county law enforcement vehicle, Department of Law Enforcement vehicle, or DLNR, Division of Conservation and Resource Enforcement vehicle, as is defined in HRS 291-31.5. Sorry for that, but that's my recommended amendments. And HB 2748, also defect the date to year 3000 and make technical amendments. Questions or concerns, members? Yes, Representative Holt.
Thank you, Chair. I appreciate the intent of this measure and all the work that you're putting into it. When noting the testimony from HPD and the 4 different counties that we do have across our state, I think it's important we respect their, give them the leadway that they need. I understand that there have been some high-profile possible violations of the current pursuit policies, but I don't think creating a statewide policy would prevent the bad actors from violating these policies. So I'll be voting in opposition.
Understood. I appreciate that. Thank you. Other questions or concerns, members? If not, Vice Chair for the vote.
Voting on House Bill 2748, HD2, noting the reservations of Representative Holt. Any other reservations or noes?
No vote.
I'm sorry. I misheard. Any other reservations or noes? Recommendations adopted.
Thank you. Next measure, HB 2581, relating to emergency management. I'd like to move this out with technical amendments and defect the effective date to the year 3000. Questions or concerns, members? If not, Vice Chair for the vote.
Voting on House Bill 2581 with amendments. Any reservations or noes? Recommendations adopted.
Thank you. House Bill 2184, I would recommend we move this out with amendments. I want to adopt the amendments recommended by the Attorney General and by the Campaign Spending Commission, make technical amendments and defect the effective date to the year 3000. And that's it. Any questions or concerns, members? If not, Vice Chair for the vote.
Voting on House Bill 2184 with amendments. Any reservations or noes? Recommendations adopted.
Thank you. On House Bill 2072 relating to campaign finance, I recommend we move this out with amendments. I'd like to adopt the Campaign Spending Commission's recommended amendments, make technical amendments, and defect the effective date to the year 3000. Questions or concerns, members? Yes, Representative Gannon.
Thank you, Chair. I understand the concern coming after the August 8th fire in Lahaina and the way various organizations, political or non-political, raised funds. I think that those who run for office are already subject to numerous laws across numerous agencies, and the behavior that we're trying to curb here is just straight up fraud. So I'm not sure if adding another felony is going to do anything here. So for those reasons, I'll be just voting with reservations.
Thank you, I appreciate that. Any other questions or concerns? If not, Vice Chair for the vote.
Voting on House Bill 2072 with amendments, noting the reservations of Representative Ganadin. Any other reservations or noes? Seeing none, recommendation is adopted.
Thank you. Next measure, House Bill 2470, relating to contested cases. Cognizant of the opposition of Earth Justice and Mr. Frankel, also cognizant of Life of the Land saying that we should replace the word may with shall, I'd like to take the middle road here and just move this out with a defective effective date and make some technical amendments and continue this discussion. And I'd like, it'd be good for DLNR and Earth Justice to talk about this offline and see if there's anything that we can do to improve this. And maybe you'll never come to agreement, but you know, I think I want to move this over for further discussion to the Senate. So my recommendation is move this out with technical amendments and defect the effective date to the year 3000. Questions or concerns, members? Representative Ganadin.
I think this bill is pretty in the weeds in discussing appellant legal practice. I think that we have an adequate process right now, and we shouldn't mess with it. So for that reason, I'm going to be voting no.
Okay, understood. Other questions or concerns, members? If not, Vice Chair for the vote.
Voting on House Bill 2470 with amendments, noting the no vote of Representative Ganadin. Any reservations or other noes? Seeing none, your recommendation is adopted.
Thank you. Let's move to the measures that we have for decision-making only. First up, HB 1812, HD1. I recommend we move this out with amendments. And these will be the amendments on page 7, line 6, changing 72 hours to 24 hours to align with the current rules under the Department of Corrections and Rehabilitation's policies called Corrections Administration Policy and Procedures. It's found on page 3. On page 7, line 9, I want to remove the language, quote, and a review every 15 days thereafter. And then I want to add the following language on page 25. We actually were able to pull this language from the public report regarding the Special Housing Incentive Program. And what we'll do is add the language that I'll read now. Section 4, following the initial hearing for the placement of an individual into solitary confinement, immediate notification and transmission of all relevant documentation and evidence from the Department of Corrections and Rehabilitation to the Hawaii Correctional System Oversight Commission shall be mandatory. The Hawaii Correctional System Oversight Commission shall thoroughly review all determinations regarding the imposition of solitary confinement for fairness, impartiality, alignment with best practices, and other factors the Commission finds relevant, and shall issue quarterly reports on the utilization thereof. Furthermore, in order to ensure strict adherence to the solitary confinement procedures delineated within this chapter, and to prevent the Department of Corrections and Rehabilitation or its contracted entities from implementing cell confinement exceeding 20 hours without proper adherence to the procedures outlined in this section, the Hawaii Correctional System Oversight Commission shall actively monitor and review all housing placements involving individuals subjected to 20 or more hours of cell confinement, irrespective of whether such placements are designated as solitary confinement by the department or state contracted facilities. And then we'll also note the effective date of no later than July 1, 2025 on page 19 as time for the Department of Corrections and Rehabilitation to effectuate the framework this bill provides and how this is in line with what the director said in the hearing about reviewing rules with the new agency. Those are my recommendations to pass out HB 1812 HD1 with amendments. It already has a defective effective date, which we'll keep. Questions or concerns, members? If not, Vice Chair for the vote.
Voting on House Bill 1812 HD1 with further amendments. Any reservations or noes? Recommendations adopted.
Thank you. On House Bill 1562, I recommend we defer this measure. In preference, we will move, my recommendation is to pass House Bill 2526 HD1 with amendments. They're both seeking to address the same issue. And working with the introducers of both bills, we reviewed proposed House Draft 2s for each one, and I'm going to recommend we move out HB 2526 HD1 with amendments. And the changes will be, the draft is straightforward. It will increase the penalty for the third driving without a license to a Class C felony up to 5 years imprisonment and/or up to $10,000 fine. It authorizes the judge at the time of sentencing to forfeit the vehicle used in the commission of the crime, and it adds a purpose section that explains the two provisions that I just outlined. That's my recommendation, to move it out with a defective date. Questions or concerns, members? If not, Vice Chair for the vote.
Waiting on House Bill 2526 HD1 with further amendments. Any reservations or noes? Your recommendation is adopted.
Thank you. There being no further business before this committee, we are adjourned.